Hello everybody, my name is Shivam Mishra and I am advocate practicing in law. In this video lecture, we will understand the court proceeding in a criminal matter. As we aware about that fact that lodging the FIR is a first step to start the criminal line of motion, and the next step is the investigation stage. But before discuss about the investigation stage, we must aware about the part that offences can be categorized into the two parts: cognizable type of offences and non-cognizable type of offences. Cognizable type of offences are those offences they are in a grievous in nature and in a practical way 3-year plus punishment that comes in the cognizable type of offences, and that is defined in our CRPC under section 2C. And if we discuss about the non-cognizable type of offences, they are in simple in nature, in a practical way 3-year below punishment they are comes in the non-cognizable type of offences, and that is defined in our CRPC under section 2L. In the case of cognizable type of offences, police lodge the FIR under section 154, then start the investigation. But in the case of non-cognizable related offence related information, police lodge in the form of NCR, but police will not start the investigation of that matter without the permission of magistrate. When magistrate will give the permit to police officer under section 155 subclass 2, then police officer will start in the non-cognizable offence related issues. Police will also start the investigation. So in a summary manner, means in the case of cognizable cases, police lodge the FIR under section 154 and start the investigation. In case of non-cognizable offence related issues, police will take the permission from the magistrate under section 155 subclass 2, and after that police will start the investigation. So next step is investigation stage. The main purpose of investigation is that to collecting the evidences. For collecting of evidences, police officer take a statement of witnesses under section 161, collecting the documents like as a medical report, like as a scientific proof, like as a call detailing, many other things, collecting other evidences also, and police can use his power of arrest, search, seize also. Means police officer collecting all the evidences, and after the collecting of all evidences, police make his investigation report in the form of either charge sheet or in the form of closure report under section 173 of the CRPC. When investigation report comes in the form of closure report, then another party make an application for the protest petition. But if it comes in the form of the charge sheet, then magistrate will take a cognizance of that charge sheet under section 190. And some of the cases when the offence is triable by the court of session, then magistrate commit that matter under section 209 to a court of session. Some of the technical term is there. Before taking the cognizance, magistrate check the sanction related issues. What is the sanction related issues? I had made a video on the topic of sanction in a detail, and that is also uploaded in our channel. You can go through and you can get a full information about the sanction. So after the cross check of the sanction related issues, magistrate take the cognizance, and when the magistrate take the cognizance, then the accused person make application for discharge. Why? Because police officer make his adjunctive power for all of the investigation report. But now magistrate will apply his judicial mind that if any prima facie case is made out or not made out. If any prima facie case is not made out, then accused will be discharged. But if any prima facie case is made out, the magistrate will frame a charge against the accused. And after the framing the charge sheet against the accused, the next stage will come where the plead guilty stage, where the magistrate will ask to the accused that is he accept the allegation, accept the charge what magistrate made against him. If accused person deny, the next step is prosecution open the cases. When the prosecution open the cases, then one step also comes under section CRPC 294, where the seized document is admit or deny with the both parties. And the next stage, when the charge is framed, the prosecution starts his witnesses. The prosecution witnesses will come, and there the statement is going to record, and another party means the accused and or his lawyer can cross-examination these witnesses. This is the stage. After the prosecution witnesses, next stage is that stage of accused persons recorded under section 313. Means when the accused, when the prosecution evidence is completed, then the next stage is statement of accused recorded under section 313. After that, if any defense witness is available, then the defense witnesses still will be comes, and another party adverse party will be cross examination of that the witnesses of the defense party. So the next stage after the evidences of the recorded from the prosecution witness and 313 statement of accused, and if any defense examination, then the next stage is come the final argument. Final argument means there is a oral argument and written memorandum, and that is defined in our CRPC section 314, and court will observe all the evidences, prosecution evidences and defense evidences, all the witnesses statement and the cross examination statement, and all the article which is seized, like the gun, knife, etc, whatever seized, that court will observe all the document which is exhibited, and many other things court will observe, and the final that court comes in the conclusion of the judgment stage. Judgment by the court means where the first way where the acquittal of the accused, then the case is over, this is a stage. But when the conviction, when the court convicted to the accused, then the one stage is also, that is the argument on how much punishment to be given. This is a stage in the case of conviction of the accused. And after this stage, when the argument on the punishment of the given to be given, then the final statement where the accused is convicted, punishment given to him, either the imprisonment or fine or both. So this is the whole proceeding where the criminal proceeding, where the criminal process from the FIR to judgment. Again, I am repeating in a very summary manner. Lodging the FIR after the investigation by the police officer. Police makes the investigation report in the form of the charge sheet. Then the magistrate take cognizance of the charge sheet. Then the prosecution evidence will become, and the other party cross examination, the 313 statement of the accused person, defense, then next stage is defense witnesses, and the final argument is stated, then judgment of the court. And if accused is convicted, then when another stage is that argument, how much punishment to be given, and then comes to the final of the punishment. So this is a whole stages which need to follow in the case of criminal proceeding.